So very good evening all the participants. Today we will be starting with part 3. Now can anybody tell me what are the things you have to study together to understand and comprehend part 3? Like in part 2, you were studying the provisions which are given in the sections. Then you were studying the application to adjudicating authority rules and then regulations. But here in individual insolvency, what are the things you will read together? Can anybody tell me? And whether all the provisions relating to part 3 have been notified or not?
No, sir. Only personal guarantee to corporate debtor.
Right. So only provisions relating to personal guarantors to corporate debtors have been notified. Like we will be reading the fresh start process. But whether there are any rules for this fresh start process? Suppose an individual wants to make an application for fresh start process, can he make as of today? The answer is no, because there is no form corresponding to it. You can make an application only if there is a form. There is an individual who has taken a loan, and now because he could not pay, now the creditor wants to initiate proceedings. So can he initiate under IBC as of now?
No, sir.
No. Right.
Under surface.
Right. SURFACE or DRT, depending upon whether it is secured or unsecured loan. So here there are 3 processes, and they could ask a case study on any of these 3 processes. So it doesn't matter whether the rules and regulations have been notified or not, because they will ask the questions from the sections. Sections are there. Sections are notified. Only rules and regulations are not there in respect of fresh start, insolvency and bankruptcy. Rules and regulations have been notified only for personal guarantors to corporate debtors, which can be either individuals or partnership firms. So with this understanding, let us start this process of part 3, and let me share my PPT also with you. I hope now it is visible. Is it visible on your screen?
Yes.
Okay. So this is part 3. So section 78. What it says? It says this part shall apply to matters relating to fresh start. So there are 3 types of matters, and there could be 3 types of case studies which they may ask whether or not rules or regulations are there or not. So this part shall apply relating to fresh start, insolvency and bankruptcy of individuals and partnership firms where the amount of default is not less than 1000 rupees. So here also there is a minimum default amount, and that is it should not be less than 1000 rupees, provided that the central government may by notification specify the minimum amount of default of higher value which shall not be more than 1 lakh rupees. Maybe this is the reason that the government has not yet notified the regulation. The minimum amount is very low. So if rules and regulations are notified, then there could be a situation where the tribunals will be inundated with multiple lots of applications because the threshold is very low. Maybe
1000.
Yes, maybe that in the times to come they amend the act. Now if they want to increase it beyond 1 lakh, up to 1 lakh they can increase it simply by issuing notification. But now suppose they want to make it 10 lakhs or 20 lakhs, then they have to amend the code. So section 79. Section 79 says in this part unless the context otherwise requires. So please tell me another question here. Suppose there is a personal guarantor to a corporate debtor. Okay? Since he is a personal guarantor, so in his individual capacity, he has given a guarantee against the loan. There could be a partnership firm also, which has given guarantee for the loan taken by the corporate debtor. So in that case, what will be the default amount? Whether 1 lakh or 1 crore?
One crore, sir.
1 crore?
1 crore.
Anybody with 1 lakh?
Sir, question can you repeat, sir?
Question is, there is an individual, a company took a loan.
Okay.
That individual is a director in that company. Because the company could not pay, now the bank guarantee was invoked and this person also could not pay. Now they want to initiate proceedings against this person. So whether the default amount for proceeding against this guarantor is 1 lakh or 1 crore rupees? That is the question. Or 1,000.
1 crore only, sir.
1,000. Because it will be proceeded under debt recovery tribunal.
No. He will not be
Oh.
proceeded against debt recovery tribunal because
Oh.
this section 79(1) we have to read along with section 60. So if you go to section 60, what it says? Section 60 subsection 1. Section 60 subsection 1 says the adjudicating authority in relation to insolvency resolution and liquidation for corporate persons, including corporate debtors and personal guarantors thereof, shall be the NCLT, having territorial jurisdiction over the place where the registered office of the corporate person is located. So
It must be 1 crore rupees.
as
It should be.
theoretically, it is 1,000 rupees, but tribunals are not accepting the application unless the default amount is proved to be 1 crore rupees. And the adjudicating authority for proceeding against the personal guarantors is NCLT. Because if we read section 60 subsection 1, it is clearly written there. For corporate persons, including corporate debtors and personal guarantors thereof, shall be the NCLT having to it. So section 79(1) has to be read along with section 60 subsection 1. So as of now, if you want to proceed against an individual in DRT, there is no procedure under IBC because there is no rule, there is no regulation. For the personal guarantors, you will have to initiate the proceedings with the appropriate NCLT having jurisdiction over the CD for which he gave the guarantee. But we have to read these provisions because once the rules and regulations are notified, then this will become fully effective. Okay? As of now, there are only sections and no rules and regulations. Rules and regulations are there only for personal guarantors to corporate debtors, which may be an individual or a partnership. So in this part, unless the context otherwise requires, adjudicating authority means the DRT. So there is a concept of associate here as against the concept of relative or related party in case of corporate persons. Here, the concept is of the associate of the debtor. Now, who is an associate of the debtor? Pradeep ji, can you read?
The associate of the debtor means the person who belongs to the immediate family member of the debtor.
And what is the meaning of immediate family?
Related to the
Ascendant, descendants. Legal
Ascendant and descendant.
legal
Immediate family is also defined here in section 79, subsection 17. What it says? I hope now it is visible on your screen.
Yes. His
Immediate family
Ah.
of the debtor means his spouse, dependent children, and dependent parents.
Huh. So whether for dependent children there is any age criteria? The answer is no. Suppose parents are independent. Suppose parents are earning on their own. Then whether they will be included in the concept of immediate family?
No, sir.
No,
No. So here, just
he
remember
must be
2, 3.
dependent.
And suppose spouse is earning. So whether she will be covered in immediate family?
Yes.
No, no, sir. She is
Yes.
earning.
Yes, sir.
It
Here
depend,
it
not
is
dependent.
just spouse, not
He is
dependent,
not
independent,
dependent,
not
but he is, she
यहाँ
is
सर
spouse.
स्पाउस लिखा है डिपेंडेंट इंडिपेंडेंट
Right.
not.
Okay, okay,
Ah.
okay, sir, okay.
So spouse?
Okay, spouse is always included.
Yes.
Spouse, whether she is earning.
Yes. Yes. Dependent children and dependent parents. No age criteria for children.
Right.
Whether
Children
married
and
or
parents.
unmarried, whether daughter or son, no such criteria. And dependent parents. So parents, if they are independent, they are not included. Okay? In the concept of immediate family. Clear? Chaliye.
Family. Right.
Next person. A person who is a relative of the debtor. Yes, Pradeep ji.
Yes, sir. So
Second point.
a person who is a relative of debtor or relative of the spouse of the debtor.
Yes. So now, where you will find the definition of relative? Relative कौन है? Relative. It is given in explanation after point number G. So क्या बोलता है? Explanation. Please read the explanation.
For the purposes of this subsection, relative with reference to any person means anyone who is related to another if they are members of a HUF. One person is related to other in such a manner as may be prescribed.
Right. So now it takes us to rule number 4. And rule number 4 takes us to section 5, subsection 24A, which gives the detailed list of relatives. That list we have already seen. But for the sake of brevity, I'll show you that list also. Let me show you application to adjudicating authority rules. Insolvency resolution. Achha. Yeah, again, relative, yes. So relative, this is given here in rule number 4. What it says? Rule number 4. I hope it is visible on your screen.
yes, sir, yes.
Yes. क्या है अजय जी पढ़िए जरा.
For the purpose of clause 2 of explanation to subsection 2 of section 79, the manner of relationship shall mean the manner as provided in the explanation to clause 24A of the section 5.
हाँ, वो वहां पर ले गया आपको. और फॉर दैट आई विल गिव यू अ चार्ट ऑल्सो, है ना. एक चार्ट भी मैंने बना रखा, उस चार्ट भी मैं आपको दे दूंगा. और 524 है आपने पहले भी पढ़ा हुआ. चलिए दोबारा चलते हैं वहीं पर ही. Yes. Now third person. A person who is in partnership with the debtor. Third clause कौन सी हो गई? So
Suppose-
your partner. If you are a person, so if you are in partnership with the debtor, then you are considered to be associate. ठीक है.
Sir, in case of a relative, any other person as may be specified, mean
कहाँ? वो जो देख रहे थे हम लोग.
relate. Yes, sir. Section 5 of section 24.
हाँ.
Relatives. May any person other any individual as may be specified as a something regulation rules 4 में section 5 of section 24A में
हाँ हाँ.
any as may be specified, मतलब it is not still not specified. Yeah, it
कहां पर कह रहे हो
list
आप?
is not is just. सर
524
जहाँ
में?
रिलेटिव, जहाँ जहाँ पे रिलेटिव का पढ़ा फर्स्ट सेकंड पॉइंट था, एनी इंडिविजुअल,
हाँ
सेकंड पॉइंट
हाँ, a person who is a relative of the debtor or a relative of the spouse of the debtor, यहाँ
यस,
तो
इसी का है जो
applicable to
सेक्शन
adjudicating authority
24 में
की
गए
बात कर रहे हो आप?
जी। इसके बाद जो गए थे सर दूसरी जगह, उसमें दो लाइन था, एक फर्स्ट पॉइंट सेकंड पॉइंट में था एनी पर्सन ऐसा करके, एज मे बी स्पेसिफाइड, ऐसा सेकंड पॉइंट वाज
ये
नॉट
है ना,
क्लियर स्टिल।
ये दे तो दिया आपने, ये रूल 4 में चले गए ना यहाँ से,
ओके,
यहीं से तो हम रूल 4 में गए, एज में भी
जी
प्रेस्क्राइब्ड
जी,
लिखा, तो व्हेन दे
हाँ
आर यूजिंग द
ये,
वर्ड प्रेस्क्राइब्ड इट मींस रूल्स,
yeah, one person is related to other in such manner as may be specified.
एज में भी प्रेस्क्राइब्ड.
हाँ, one
So
person is
whenever they
related to
use the
other
word
in such
prescribed, it means they are
हाँ,
referring to some rule. So rule number 4 I have
ओ-
given. Rule number 4, section 524A.
ओके,
In the PPT I am sharing rule number 4. Maybe you are reading from the book. आप बुक से पढ़ रहे हो, यहाँ से पीपीटी से देख रहे हो?
पीपीटी से इधर देख रहे
इसमें तो लिखा है ना रूल नंबर 4. रूल नंबर 4
Yes,
मैंने
yes.
आपको दिखाया,
हैं।
एप्लीकेशन
it means it is not exhaustive list ना सर, as may be prescribed, not specified.
अरे वो सेक्शन 524A में लिखी है ना लिस्ट,
एग्जॉस्टिव लिस्ट है सर।
और क्या दिखाऊं क्या वो भी?
ओके सर, दिखा देंगे सर, अच्छा रहेगा।
नहीं नहीं, दिखा देते हैं, उसके भी दर्शन करा देते हैं आपको, ऐसी क्या बात है? वो
जी
आपका ये जो अपडेटेड कोड वाली पीपीटी है ना, उसमें दिखा देते हैं. एक मिनट लगेगा. लो जी, दर्शन करो इसके अपडेटेड कोड. ठीक है जी, ये नजर आ रही होगी आपको. अब इसमें आपको
yes,
सेक्शन
sir.
5 सब सेक्शन 24 पर जाना है. ये गए आप सेक्शन 5 सब सेक्शन 24. ये लिस्ट है पूरी,
ओके
ये दे रखी है ना,
ओके
मेंबर्स ऑफ एचयूएफ, और ये सारी लिस्ट, ये पूरी लिस्ट है.
Okay,
हस्बैंड,
it
वाइफ,
is.
फादर, मदर, सन, डॉटर, सब दिया हुआ.
Yes, but sir, why there is written as a specified, may be specified, not written as a
प्रेस्क्राइब्ड लिखा सर,
specified.
प्रेस्क्राइब्ड.
Okay,
Described it.
तो प्रेस्क्राइब में रूल दे रहा है, रूल ले गया 524A पर, ये 524A
Okay.
दिया आपको.
as may be prescribed under rule.
हाँ, तो रूल नंबर 4, I took you to rule 4 ना, and rule 4 takes you to section 524A. सेक्शन 524 कैपिटल मैंने आपको दिखा दिया.
Okay, sir, thank you.
बस, और मेरी जान लोगे क्या? ठीक है जी,
डाउट क्लियर हो गया सर,
है ना, क्लियर हो गया ना?
डाउट क्लियर।
नहीं नहीं, जरूरी है वो. यस, नाउ नेक्स्ट, यही तो है घुमावदार, इसमें यही तो है. ए पर्सन हु इज इन
आप सर
पार्टनरशिप.
इतना मेहनत कर रहे हैं, आपका मेहनत भी नहीं खराब होना चाहिए, हमारा मेहनत तो
ये
ठीक
तो है, बिल्कुल ठीक बात है, बिल्कुल सही बात, आई अप्रिशिएट. बिल्कुल सही बात. नहीं, उसका पर्पस भी देखो, ऐसा है कि मेरा पर्पस तो आपको समझाना, अगर आपको ही समझ में नहीं आया तो मेरा पर्पस बेकार है नहीं?
बिल्कुल 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 सर। मैं सुबह 9 बजे से सर तो एआई के क्लास में था, फिर भी मैं अंजू सर का क्लास अटेंड करते।
अरे वाह. ए पर्सन हु इज इन पार्टनरशिप विद द डेटर. ठीक है, क्लियर है, तो उसमें कोई दिक्कत नहीं. ए पर्सन हु इज ए स्पाउस और रिलेटिव ऑफ एनी पर्सन विद whom द डेटर इज इन पार्टनरशिप. स्पाउस तो मतलब क्लियर है, और रिलेटिव का मतलब हमने देख लिया. ठीक है, पर्सन हु इज एम्प्लॉयर ऑफ द डेटर और एम्प्लॉय ऑफ द डेटर. ए पर्सन,
एम्प्लॉयर एंड एम्प्लॉय बोथ आर.
हाँ, एम्प्लॉयर एम्प्लॉय बोथ आ गए. ए पर्सन हु इज ए ट्रस्टी ऑफ ए ट्रस्ट in which the beneficiaries of the trust include a debtor, or the terms of the trust confer a power on the trustee. Just a minute. Which a person who is a trustee of a trust in which the beneficiaries of the trust include a debtor, or the terms of the trust confer a power on the, एक मिनट, इसको मैं थोड़ा सा ये ज्यादा ही खींच दिया लगता है, थोड़ा सा इसको थोड़ा ऐसे कर दो क्या, वो जूम पे फिर प्रॉपर हो नहीं पा रहा, अब हो जाएगा बेहतर। हाँ, so point number F is a person who is a trustee of a trust in which the beneficiaries of the trust include a debtor, or the terms of the trust confer a power on the trustee which may be exercised for the benefit of the debtor. Now, let us understand this concept. ये concept कोई समझा सकता है क्या मुझे? Point number F क्या है? What is the meaning?
Where it is a trust where the debtor is a beneficiary, so the trustee of the trust is a associate.
Right, very good, very correct. A person who is a trustee of a trust, suppose there are 4 trustees in a trust and one of the beneficiaries is the debtor. Okay? Or the terms of the trust confer a power on the trustee which may be exercised for the benefit of the debtor. So then that trustee and this debtor, they are associates. Very good.
Associate.
A company where the debtor or the debtor along with its associates owns more than 50% of the share capital of the company or control the appointment of the board of directors of the company. Now what is the meaning? A company where the debtor or the debtor along with his associates, we have already read the definition of associate. ठीक है, ये सारा एसोसिएट में ही चल रहा है। ये कौन कौन से एसोसिएट में आ गए? ये सारे 2A, B, C, D, E, F, G, ये सारे एसोसिएट ही है up to F. Now you take the case of the company where the debtor or the debtor along with his associates owns more than 50% of the share capital of the company or control the composition of the board of directors. So in that case, that company and the debtor will be deemed to be associates. ठीक है? For the purpose of this subsection, relative with reference to any person means anyone who is related to another if they are members of HUF, or one person is related to other in such manner as may be prescribed. ठीक है? Rule 4, and Rule 4 again takes us to section 5, subsection 24.
5 to 20.
Bankrupt means, yes, Pradeep ji, padhiye jara. Bankrupt. Bankrupt means?
Yeah, bankrupt means
हाँ,
a debtor who has been adjudged as bankrupt
हाँ.
by a bankruptcy order under section 126.
Now, let us understand the meaning. What is the meaning? The meaning is a debtor who has been adjudged. So, adjudication, as you know, is a process, है ना? Which is followed by the adjudicating authorities or legal authorities. Suppose bankruptcy proceedings have commenced against a person. So, in that case, that person will be deemed as bankrupt. So, bankrupt, in common parlance, what we understand? We understand that is bankruptcy is complete. No, bankrupt means that bankruptcy proceedings have started. If bankruptcy proceedings are complete and discharge order is issued, then he is as good as an ordinary person.
Ordinary person, right.
ये understand करना है अपने को.
Okay.
Each of the partners of a firm where bankruptcy order under section 126 has, suppose a firm has given a guarantee. Now the firm could not pay. Firm could not present a repayment plan. Here in part 3, there is a concept of repayment plan. There is no concept of resolution plan in part 3. Okay? So in this case, if a firm gave a guarantee and firm could not pay, they could not produce a repayment plan also. And now bankruptcy proceedings have started. So then in that case, each of the partners of the firm will be deemed to be bankrupt. Third person, any person adjudged as an undischarged insolvent. Now what is the meaning? Undischarged insolvent means insolvency proceedings have started, but discharge order has not yet been made. ठीक है, जो भी प्रोसेस होगा ना इसमें जितने भी प्रोसेस होंगे एंट्री और एग्जिट है, ठीक है। चाहे फ्रेश स्टार्ट हो, एडमिशन होगा, डिस्चार्ज ऑर्डर होगा। इंसॉल्वेंसी में एडमिशन होगा,
Means, sir, a judge,
डिस्चार्ज ऑर्डर होगा।
sorry,
Yes.
sir. A judge as bankrupt, what is difference between a judge as bankrupt and a judge as undischarged insolvent?
हाँ, एडजस्ट एज अनडिस्चार्ज इंसॉल्वेंट लिखा ना भाई। देखिए,
Right.
देर आर टू प्रोसेसेस। पहले क्या होता है, इंसॉल्वेंसी स्टार्ट होती है। लाइक इन केस ऑफ पार्ट टू में भी क्या होता है, पहले रेजोल्यूशन होता है, पहले CIRP होगी, फिर लिक्विडेशन होता है ना। Directly, there is no concept of liquidation. Similarly, here, first of all, they will start the insolvency proceedings. If he pays, fine. If he doesn't pay, then bankruptcy will start. In case of part two, what happens? First of all, they try for resolution. If there is a resolution plan, then fine. If there is no resolution, then liquidation. Similarly, here, adjudged as undischarged insolvent means insolvency proceeding started, but no discharge order has yet been made.
Means in both the cases, bankruptcy is going on.
No, actually, part three, this any person adjudged as an why they have given this concept, because that Presidential Insolvency Towns Act, वो भी अभी चल रहे थे ना पीछे, केसेस वर गोइंग ऑन, और प्रोविंशियल इंसॉल्वेंसी एक्ट, उसमें भी केसेस चल रहे थे इंसॉल्वेंसी वाले. So there could be a case where insolvency proceedings are going on against some under some other act apart from IBC. So that is referring to that actually. यहाँ पर ये मतलब
Provincial and president दोनों.
हाँ बिल्कुल. Bankruptcy means the state of being bankrupt. ठीक है. Bankruptcy debt, ये bankruptcy वाले जो definitions हैं, that we will study when we study the provisions relating to bankruptcy, है ना. अभी पढ़ने से भी समझ में नहीं आएगा अभी हमें, क्योंकि फ्रेश स्टार्ट करना है. अभी हम लेट अस स्किप दिस डेफिनेशंस और हम सीधा जो फ्रेश स्टार्ट से रिलेटेड डेफिनेशंस हैं उन पर चलते हैं.
Okay.
Discharge order. Discharge order means an order passed by the adjudicating authority discharging the debtor under section 92, 119 and 138. 138 is with relation to bankruptcy, 119 related to insolvency, and 92 relating to fresh start process. Excluded assets. This is very important definition. Excluded assets for these purposes of this part include. Yes, Pradeep ji, padhiye jara.
Yeah. So unencumbered tools, books.
Yes. What is the meaning of unencumbered?
Where there is
Not mortgage anywhere.
Yeah.
Free
Right.
from
Right.
trades.
Free from any security interest. No security interest has been created. Free. Free from encumbrances. Unencumbered. Encumbrance means?
Given as a security.
Yes. So unencumbered
Okay.
means free from any security. Free from any
Security.
encumbrances. Yes. No security interest created. No loan basically taken. Yes. No charge
Right.
created. Yes.
Not pledged anywhere.
Right. Very correct. Pledge, mortgage, hypothecated, nothing.
Yeah.
Yes.
Books, vehicles, and other equipment as are necessary to the debtor or bankrupt for his personal use or for the purpose of his employment, business, or vocation.
So if there are any such tools, books, vehicles, and other equipments which are necessary for the bankrupt or the debtor for his personal use or for the purpose of his business, because when you are starting insolvency or bankruptcy proceedings, you cannot expect that he will stop his business or will stop his profession, है ना. वो अपना काम तो करेगा ना. तो इसके लिए क्या किया उन्होंने? Provided you have not taken any loan. Suppose you are owning a car and you have taken loan, then it will not be covered under excluded assets. Okay? But if there is no loan, then that is free. And they are referring to the word vehicles, not a vehicle. So there could be more than one vehicle also. Yes, please. Next.
Unencumbered furniture, household equipment, and provisions as are necessary for satisfying the basic domestic needs of the bankrupt and his immediate family.
Yes. Now, can you make a distinction between A and B? In A, they are referring to personal use or business use. But here, they are referring to domestic needs of the bankrupt and his immediate family. So, immediate family also is covered. But in the case of first A point, 14A, immediate family is not covered. Okay? This is the difference. Next point.
Any unencumbered personal ornaments of such value as may be prescribed of the debtor or his immediate family, which cannot be parted with in accordance with religious usage.
Yes. So, in application to adjudicating authority rules, so they have given that, okay, personal ornaments up to the value of 1 lakh rupees. Okay? So, they have prescribed a value to this. Yes.
Any unencumbered life insurance policy or pension plan taken in the name of debtor or his immediate family.
So, this is also included in the definition of excluded assets. Yes.
An unencumbered single dwelling unit owned by the debtor of such value as may be prescribed.
So, this value prescribed is given in Rule 5 and it says 10 lakhs in rural area, 20 lakhs in urban area. Yes. So,
That
what
means
is the significance of excluded assets? So, normally they will not be touched because they are needed for his survival or for his business. So, provided he has not taken any loan or he has not created any security interest. If he has taken loan against all these assets or he has created any security interest, then it will not be covered under excluded assets. Yes, please. Next. Next point, excluded debt. Yes, Pradeep ji.
Yeah. So excluded debt means a liability to pay fine imposed by a court or tribunal.
Next.
Liability to pay damages for negligence, nuisance, or breach of a statutory, contractual, or other legal obligation. Liability to pay maintenance to any person under any law for the time being in force. Liability in relation to a student loan and any other debt as may be prescribed.
So, this is also a very important concept of excluded debt. Now, what is excluded debt? Even if, so we have read the definition of discharge order. Okay? So, even this discharge order, if we read this definition, if we go to section 92, so it says what section 92 says. So, section 92, if we read section 92 says the adjudicating authority shall pass a discharge order for discharge of the debtor from the qualifying debts. And what is the meaning of qualifying debt? Qualifying debt also has a meaning. So, qualifying debt is a debt which does not include an excluded debt. So, that means even if a discharge order is issued, he will still be responsible for payment of all these excluded debts. So, these debts will not be discharged. He will not be discharged from these debts. Okay? By what they presume? They presume that the person will remain alive. Na? He will continue to work. Although there might be insolvency or bankruptcy, but till he is alive, he will continue to work. So he will be earning. So he has to pay out of that amount. Excluded debt. So he will not be absolved. He will not be exonerated. He will not be discharged from these excluded debts. Even despite the issue of a discharge order. What he will be discharged of? He will be discharged from the qualifying debts only and not from excluded debts. Yes. Yes, Pradeep ji, next definition. Firm.
Firm means a body of individuals carrying on the business in partnership, whether or not registered under Section 59 of Indian Partnership Act 1932.
So here, a very important thing, what they have done is they have defined the term firm and not partnership firm. Although defining the term firm, they mean partnership firm only. But if we read section 78, what section 78 says? Section 78 says partnership firms. This part shall apply to matters relating to fresh start, insolvency and bankruptcy of individuals and partnership firms. Now, if they ask you a question whether the term partnership firm has been defined in section 79, the answer is no. So they have defined the term firm, which means partnership firm. Okay? Yes, immediate family. Immediate family, this definition we have already seen. Spouse, dependent children, dependent.
And dependent parents.
Partnership debt means a debt for which all the partners in a firm are jointly liable. This definition is also very important because a partner might have contracted certain debts in his individual capacity also. Suppose A, B, and C are partners in a partnership firm and he has taken a housing loan also. So that housing loan has got nothing to do with that partnership firm. So in partnership debt, they are referring to a debt for which all the partners in a firm are jointly liable. Okay? Now qualifying debt. Yes, Pradeep ji padhiye qualifying debt.
Qualifying debt means amount due, which includes interest or any other sum due in respect of the amounts owed under any contract by the debtor for a liquidated sum, either immediately or at certain future time. And it doesn't include an excluded debt, a
Yes.
debt to the extent
So
it is
excluded debt, we have already seen the definition. है ना? Excluded debt, we have already seen the definition. Liability to pay fine, liability to pay damages, liability to pay maintenance, liability in relation to student loan, etc. etc. Second,
a debt to the extent it is secured.
so if a debt is secured, then also it is not included in the qualifying debt. In section 92, what we have read just now, in section 92, we have read that he will be discharged from the qualifying debt only.
Debt only.
So that means he will not be discharged from the secured debt also. है ना? Yes. Next. And
Any debt which has been incurred 3 months prior to the date of the application for fresh start process.
yes. So because in fresh start, what they mean by fresh start? By fresh start, they mean that okay, you go and enjoy. You don't have to pay anything. So if a person incurs any debt 3 months prior to the date of application, so then that also will not be covered in the qualifying debt. That means he will not be discharged from any debt which he has incurred 3 months prior to the application. बोलेगा भाई मेरे को तो सारे डेट से माफ हो ही जाना है और डेट ले लेता हूं मैं, है ना? So that is why this clause has been inserted. So nothing, a debt which has been incurred 3 months prior to the date of application for fresh start. ठीक है, चलिए next.
The
Buddy, buddy.
repayment plan. Repayment plan means a plan prepared by the debtor in consultation with the resolution professional under section 105, containing a proposal to the committee of creditors for restructuring of his debts or affairs.
So here, what is the meaning? As I told you, in case of individuals and partnership firms, there is a concept of repayment plan. So this repayment plan is to be prepared by the debtor. No resolution applicant will come. है ना? And he has to consult the RP. And what it will contain? It will contain a proposal to the committee of creditors for restructuring of his debts or affairs. Yes. Next.
Resolution professional means an insolvency professional appointed under this part has a resolution professional for conducting the fresh start process or insolvency resolution process.
Yes. So there is no concept of interim resolution professional here in part 3. IRP कुछ नहीं, RP ही है. अच्छा, एक और आपको थोड़ा डिफरेंट नहीं लग रहा कि they are talking of only 2 processes, fresh start and insolvency? Why they are not talking of bankruptcy? Why in part 3 there are 3 processes, but for resolution professional they are indicating only two processes. What about the third process? Any answer? भाई सिंपल है ना, वहां पर क्या है, वहां उसका नाम बदल जाएगा. There he will not be called resolution professional, he will be called bankruptcy trustee. ठीक है, जैसे CIRP में होता ना IRP और RP, but in liquidation is liquidator. So the concept similar to liquidator is bankruptcy trustee here. ठीक, चलिए, bankruptcy trustee भी डिफाइन किया है क्या इन्होंने?
Yes, sir. In 9, subsection 9.
राइट, हाँ, तो यहां सबसेक्शन 9 में कर दिया बैंक्रप्सी ट्रस्ट, तो सेपरेट डेफिनेशन. यस, नेक्स्ट, अनडिस्चार्ज बैंक्रप्ट.
Means a bankrupt who has not received a discharge order under section 138.
Yes, so bankruptcy proceedings have been commenced, but discharge order has not yet been issued. ठीक है, so these were some of the important definitions. Now let us see this fresh start process. fresh start, अभी तक जो हो गया माफ, कुछ नहीं देना, बट वेदर आपको जो एक्सक्लूडेड डेट है वो भी नहीं देना क्या? The answer is no. You have to still pay excluded debt, you have to still pay the secured debt, you still have to pay any debts which you have incurred 3 months prior to the initiation of fresh start.
I think this is the line with the CRP process where the company gets free from its own debt, but the promoters and director doesn't get any exclusion from their personal guarantees. वैसा ही सर गया?
हाँ, नहीं, उसको नहीं इसके साथ जोड़ते तो ठीक रहेगा मेरे हिसाब से. थोड़ा सा और अंडरस्टैंडिंग डेवलप होने देते हैं, फिर चलेंगे उस पर. यस प्लीज. यस, प्रदीप जी पढ़िए पढ़िए सेक्शन 80.
A debtor who is unable to pay his debt and fulfills the conditions specified in subsection 2 shall be entitled to make an application for a fresh start for discharge of his qualifying debt under this chapter.
Yes. So what he is making? He is making an application for a fresh start for discharge of his qualifying debt, not for all the debts. Suppose he has taken a secured loan from a bank, whether he will be discharged from that obligation?
No, sir.
Suppose he has been imposed fine by the court, so whether he will be discharged?
No.
No. ठीक है, तो excluded debts are not covered, secured debts not covered, any debt incurred 3 months prior to the making of application not covered. ठीक है?
No.
Yes, next.
A debtor may apply either personally or through a resolution professional for a fresh start under this chapter in respect of his qualifying debts to the adjudicating authority if the gross annual income of the debtor does not exceed 60,000 rupees.
Yes. So this is the gross annual income. And how you will calculate this gross annual income? Whether it is on calendar year or financial year,
Financial years.
but what I will say is that you will calculate the annual income just preceding the date of making the application in the last 12 months. Nothing is written, no rules, no regulations, so there is no clarity is there. But logical explanation क्या लगता है कि suppose you are in June, है ना, you make an application on say 1st of June, so you will consider the income up to 31st May. So 1st June to 31st May of last year, ऐसा करना पड़ेगा. Annual income. Yes, please. Next.
The aggregate value of the assets of the debtor does not exceed 20,000 rupees.
Yes. So what is the concept? Aggregate value. So whether excluded assets are covered here or not? We have seen the definition of excluded assets also.
Yes.
Covered, sir. Here it is covered.
Yes, here it is covered because they are talking of aggregate. So they have made it abundantly clear that aggregate value does not exceed 20,000 rupees. ठीक है, चलिए next.
The aggregate value of qualifying debts does not exceed 35,000 rupees.
Right. So these are the three conditions. Annual income not to exceed 660, aggregate value does not exceed 20, and aggregate value of qualifying debts does not exceed 35,000 rupees. Yes.
He is not an undischarged bankrupt.
Yes. That means that there are no bankruptcy proceedings which are continuing against him. Because only in that situation will be considered as undischarged bankrupt. है ना? And
Yes,
we have seen the definition of undischarged bankrupt also.
सर ये अमाउंट
Undischarged
बहुत लो है मतलब लोअर साइड पे एक्चुअली.
Yeah, sir.
लोअर साइड पर तो इसीलिए है ना जी, डिफॉल्ट भी तो 1,000 रुपए है. डिफॉल्ट भी तो आप देखो ना, डिफॉल्ट भी तो 1,000 रुपए है ना. ये बिल्कुल ही भूखा नंगा है, उसी के लिए है ये. हाँ जी. भाई वरना तो लोन लिया तो देना तो पड़ेगा ना, ऐसा थोड़ी कि लोन लो और मौज लो.
ये सबके लिए नहीं, मतलब जो
हाँ
HNI के लिए नहीं एक्चुअली है.
हाँ. यस प्लीज. नेक्स्ट पॉइंट प्रदीप
He
जी.
doesn't own a dwelling unit irrespective of whether it is encumbered or not.
राइट. मकान भी नहीं होना चाहिए उसके पास. यस. नेक्स्ट.
A fresh start process, insolvency resolution process, or bankruptcy process is not subsisting against him.
हाँ, इनमें से कोई भी प्रोसेस नहीं चल रहा है. ठीक है. एंड
No previous fresh start order under this chapter has been made in relation to him in the preceding 12 months of date of the application for fresh start.
yes, they gave a case study in one of the examinations and they covered this point number 80G. No previous fresh start order under this chapter has been made. So they said a person has applied for a fresh start process, but then he withdrew his application. So whether he can avail this fresh start process? This was the question they asked in the examination. I hope you have understood my question.
Yes, sir.
है ना? The person, he made this application for fresh start. But before that application was admitted, he withdrew it. So then, whether he can make application or he has to wait for 12 months? This is the question.
He has to wait for 12 months.
No. Because first of all, order should have been made. Order तो हुआ नहीं ना. Application admit नहीं हुआ तो order ही नहीं हुआ. Word क्या है? No previous fresh start order under this chapter has been made.
Order.
Had this application been admitted, then he would have to wait for 12 months. अच्छा, एक और क्वेश्चन. Whether he can avail this process after every 12 months?
Yes, sir.
12 महीने हो गए, एक बार ले लिया. वो कहे भाई 12 महीने में कोई प्रीवियस फ्रेश स्टार्ट नहीं है, तो क्या दोबारा भी ले सकता है वो? हर 12 महीने में ले ले, हो सकता है क्या?
Yes, sir, it can.
नहीं, उसके लिए इससे पहले वाला क्लॉज पढ़ लो. No fresh start process, insolvency resolution process or bankruptcy process is not subsisting against him. ठीक.
Subsisting means
हाँ, कोई चालू नहीं होना चाहिए.
exist नहीं है ना वो.
हाँ.
So once in a lifetime only, sir, this is, sir.
नहीं, ऐसा भी नहीं है वन से, बट पुराना प्रोसेस कंप्लीट हो गया फिर कर सकते हो आप. बिकॉज देयर इज अ कॉन्सेप्ट ऑफ एंट्री ऑल्सो हियर. सो व्हाट दे से, यहां पर ये भी है कि एन एंट्री शैल बी मेड. ये सेक्शन 92 सब सेक्शन 5 क्या बोलता है? द डिस्चार्ज ऑर्डर शैल बी फॉरवर्डेड टू द बोर्ड for the purpose of recording an entry in the register referred to in section 196. इसका एंट्री भी हो जाएगा एक कि भाई इसने फ्रेश स्टार्ट प्रोसेस अवेल कर लिया. चल, एप्लीकेशन फॉर फ्रेश स्टार्ट ऑर्डर सेक्शन 81 पढ़िए प्लीज.
When an application is filed under Section 80 by a debtor, an interim moratorium shall commence on the date of filing of said application in relation to all the debts and shall cease to have effect on the date of admission or rejection of such application as the case may be.
So here there is a concept of interim moratorium. In all the three processes, fresh start, insolvency and bankruptcy, there is a concept of interim moratorium. Interim moratorium immediately on filing and then moratorium on the date of admission. Yes, please.
During the interim moratorium period,
Hmm.
any legal action or legal proceedings pending in respect of any of his debts shall be deemed to have been stayed,
Hmm.
and no creditor shall initiate any legal action or proceedings in respect of such debt.
Right. So, pending proceedings, stay. And no fresh initiation. What is the difference between 1 and 2? 1 is talking of pending things. And suppose some legal action or legal proceeding is going on, so stay will be granted. Second, no creditor shall initiate any legal action or proceeding in respect of such debt. Yes.
The application under Section 80 shall be in such form and manner and accompanied by such fee as may be prescribed.
But whether anything has been prescribed, the answer is no. There are no rules as of now. Yes.
The application under subsection 3 shall contain the following information supported by an affidavit, namely a list of all debts owed by the debtor as on the date of the said application, along with the details relating to the amount of each debt, interest payable thereon, and the name of the creditors to whom each debt is owed.
Yes. So, the application shall contain the following information and will be supported by an affidavit also. So, he will give the list of all debts. So, whether he will include the excluded debt also here or only qualifying debt?
All the debts, he said.
Yes, because it is. Now, who will examine whether it is a qualifying debt or excluded debt? This examination will be done by the RP only. So, he will give the list of all the debts. Yes.
The interest payable on the debts and the rate thereof stipulated in the contract. A list of security held in respect of any of the debts. The financial information of the debtor and his immediate family up to 2 years prior to the date of the application.
Yes. So this is important here. So financial information not only of the debtor but of his immediate family also. And immediate family, we all know, spouse, dependent children, dependent parents. ठीक है. एसोसिएट का नहीं है यहाँ डिटेल्स. किसका डिटेल लिया? Debtor and his immediate family. Yes.
The particulars of the debtor's personal details as been prescribed and the reason for making the application.
Yes, text point.
The particulars of any legal proceedings which to the debtor's knowledge has been commenced against him. The confirmation that no previous fresh start order under this chapter has been made in respect of qualifying debts of the debtor in the preceding 12 months of the date of application.
Right. So all these things he has to give in the application. Now, there could be two things. I know. This debtor can file the application on his own also. He can file through RP also. So in case he files the application through RP, so adjudicating authority shall direct the board within 7 days and shall seek confirmation that there are no disciplinary proceedings pending against the RP. Okay? Who has submitted such application. And board will confirm. And there are any disciplinary proceedings, then they will appoint somebody else. This is the meaning.
Sir, one question with regards to the earlier
Yes.
section.
हाँ.
If the person forget to mention any of its debts or a debt arises after this application is filed, what to do? What to do in that case?
No, that will वो आगे आ जाएगा.
अच्छा.
अभी तो क्या है, he has simply made the application. So there could be an appeal also. Even the creditor might object that his debt is not included.
Okay.
वो कवर हो जाएगा आगे. Yes. Now suppose he filed the application on his own and not through the RP. So adjudicating authority will ask the board within 7 days and board will revert within 10 days. ठीक है, जैसा CIRP में होता है, same process.
Yes, sir.
Now 83. This is very important. So in part 3, ये सब देखिए रेजगारी वाले केस है, ठीक है ना. तो in all these cases, the responsibility of the RP or bankruptcy trustee is more, because the adjudicating authority may not have that much time. So there is a concept of report here. There is no such concept of report in case of application admission by the adjudicating authority. तो उस केस में क्या वहां पर क्या है, वहां कॉन्सेप्ट ये है, adjudicating authority on its own decides, but here there is a concept of reporting, and based on the report the adjudicating authority will take decision in this part 3. So in this case the RP will examine the application, what is the time period, within 10 days, and submit a report to the adjudicating authority, either recommending acceptance or rejection of the application. ठीक है. He has given the list of all the debts we have seen at the time of application. इसने क्या कहा, इसने तो सारे डेट्स का डिटेल दे दिया है ना. अब ये क्या करेगा, उन डेट्स को 2 पार्ट में बांट देगा. कौन कौन से, क्वालिफाइंग डेट्स. The resolution, the report referred to shall contain the details of the amounts mentioned in the application, which in the opinion of the RP are qualifying debts, क्योंकि डिस्चार्ज ऑर्डर तो सिर्फ क्वालिफाइंग डेट्स का होना है.
Yes, yes.
And liability is eligible for discharge under subsection 3 of section 92. What are those liabilities? In relation to these debts, there might be certain penalties or interest. So those, he will be discharged from those liabilities also. Okay. The resolution professional may call for such further information or explanation in connection with the application as may be required from the debtor or any other person who in the opinion of the RP may provide such information. So it says he may seek information from the debtor or any other person. So here the role of associate will come. So he may ask information from associate also. And the debtor or any other person, as the case may be, shall furnish such information or explanation within 7 days of receipt of the request. The resolution professional shall presume that the debtor is unable to pay his debts at the date of the application if, yes, पढ़िए जरा एक बार प्रदीप जी.
Yeah, if in his opinion the information stipulated in the application indicates that the debtor is unable to pay his debts and he has no reason to believe that the information supplied is incorrect or incomplete, and he has reason to believe that there is no change in the financial circumstances of the debtor since the date of application enabling the debtor to pay off his debts.
Yes. Next.
The resolution professional shall reject the application if in his opinion the debtor does not satisfy the conditions specified under section 80 or the debts disclosed in the application by the debtor are not qualifying debts, or the debtor has deliberately made a false representation or omission in the application or with respect to the documents or information submitted.
Next.
The resolution professional shall record the reasons for recommending the acceptance or rejection of the application in the report to the adjudicating authority under subsection 1 and shall give a copy of the report to the debtor.
Yes. So here he has to record the reasons also for both. Even if he is recommending acceptance, he has to give reasons. If he is recommending rejection, then also he has to give the reasons. And he shall give a copy of the report to the debtor also. Yes. Whether he will give a copy of the report to the creditor, क्रेडिटर को भी कॉपी देना है क्या?
Yes, sir.
नो,
Yes.
क्रेडिटर को नहीं देना,
ये मेंशन नहीं है उसमें।
आगे आएगा क्रेडिटर करो। अभी तो ऐसा है ना, अभी पता ही नहीं एप्लीकेशन एडमिट होगी नहीं होगी, तो काय को क्रेडिटर को डिस्टर्ब करना। अभी क्रेडिटर को कुछ पता नहीं है, इसने डेटर ने एप्लीकेशन लगा दी। वेदर द क्रेडिटर कैन मेक एन एप्लीकेशन अंडर फ्रेश स्टार्ट, द आंसर इज नो। सिर्फ डेटर ही एप्लीकेशन लगा सकता है, इसमें क्रेडिटर एप्लीकेशन लगा ही नहीं सकता।
प्रोसेस थोड़ा सर पर्सनल गारंटर से मैच है, थोड़ा थोड़ा पर्सनल गारंटर में एप्लीकेशन के बाद एडमिशन के बाद ही सब कुछ अनाउंसमेंट वगैरह करते हैं।
हाँ, बट वहां तो दोनों से लगा सकते हैं ना एप्लीकेशन, डेटर भी क्रेडिटर
एप्लीकेशन
भी।
में दोनों लगा सकते हैं, बट
हाँ
प्रोसेस
बिल्कुल
मोर
बिल्कुल
और
ठीक।
मोर और
हाँ तो उसी पार्ट में तो आ ही रहा है ना, पार्ट 3 में तो आ रहा ही है, ये
Okay.
पहला ही प्रोसेस है। 84, यस, पढ़िए प्रदीप जी, एडमिशन और रिजेक्शन।
The adjudicating authority may, within 14 days of the date of submission of the report by the resolution professional, pass an order either admitting or rejecting the application made under subsection 1 of the section 81.
तो इवन इफ ही हैज रिकमेंडेड एक्सेप्टेंस, एडजुडिकेटिंग अथॉरिटी में स्टिल रिजेक्ट, है ना। टाइम पीरियड अवेलेबल विद एडजुडिकेटिंग अथॉरिटी सेम एज इन केस ऑफ CIRP, 14 days. Yes.
The order passed under subsection 1 accepting the application still shall state the amount which has been accepted as a qualifying debts by the resolution professional and the other amounts eligible for discharge under section 92 for the purpose of the fresh start order.
Yes. अब देखिए ऑर्डर में क्या लिख दिया इसने लिख दिया अमाउंट विच हैज बीन एक्सेप्टेड एज क्वालिफाइंग डेट्स बाय द आरपी का नाम लिख दिया इसमें। सो एट दिस स्टेज द एडजुडिकेटिंग अथॉरिटी इज नॉट सेइंग दैट दीज आर द क्वालिफाइंग डेट्स, वो ही इज सिंपली स्टेटिंग बेस्ड ऑन द रिपोर्ट ऑफ द आरपी कि भाई ही दिस हैज बीन एक्सेप्टेड एज क्वालिफाइंग डेट। फाइनली क्या होगा, दैट मे बी डिफरेंट। यस।
A copy of the order passed by the adjudicating authority under subsection 1 along with a copy of the application shall be provided to the creditors mentioned in the application within 7 days of the passing of the order.
अब यहां पर कॉपी दे दिया क्रेडिटर्स को, ठीक है। नाउ डेट्स आर इंडिकेटेड इन द ऑर्डर। नाउ व्हेन द क्रेडिटर सीज द कॉपी ऑफ द ऑर्डर, ही सीज दैट इट हैज बीन इंक्लूडेड एज क्वालिफाइंग डेट। वो बोलता भाई ये तो क्वालिफाइंग डेट ही नहीं है, इट्स अ सिक्योर्ड डेट और इट इज एन एक्सक्लूडेड डेट और द अमाउंट इज नॉट करेक्ट, है ना। तो बेस्ड ऑन दिस ही मे अगेन अप्रोच द आरपी, आगे आएगा उसके बारे में। नेक्स्ट 85।
On the date of admission of the application, the moratorium period shall commence in respect of all the debts. During the moratorium period, any pending legal action or legal proceedings in respect of any debt shall deem to have been stayed and subject to the provisions of section 86, the creditors shall not initiate any legal action or proceedings in respect of any debt. During the moratorium period, the debtor shall not act as a director of any company or directly indirectly take part in or be concerned in the promotion, formation or management of.
There are certain restrictions on this person now, ठीक है। He cannot dispose of or alienate any of his assets. He has to inform his business partners that he is undergoing a fresh start process. Suppose he enters into any financial or commercial transaction of such value as may be notified, 1 lakh is the amount, either individually or jointly, that is undergoing a fresh start process. Disclose the name.
इज टू लो दैट कि आई डाउट कि कोई डायरेक्टर कंपनी का आएगा इस फर्स्ट स्टार्ट में, क्योंकि 20,000 65 35,000 का
हाँ
जो
नहीं वो ठीक है, बट क्या होता है कई बार आप पीएन को भी डायरेक्टर बना देते हो, तो उस केस में हो सकता है।
उस
So
केस
what
में
if he is already a director in the company? Should he has to resign or?
हाँ जी,
What if he is already a director in the company?
हाँ तो he has to then देखा ना, director shall not act as a director of any company or directly or indirectly take part in or be concerned in the promotion. So they want to disassociate from the business basically during the moratorium period. ये हो गया ना. He has to inform his business partners also that is undergoing fresh start process. क्लियर लिख दिया ना उसमें. क्या लिखा? Not act as director of any company during the moratorium period. He cannot travel overseas also. ठीक है. ओवरसीज ट्रेवल में क्या है भाई, डिपेंडेंट चिल्ड्रन ही तो है ना उसमें. अगर मान लो कोई इंडिपेंडेंट चिल्ड्रन है, उसका बच्चा है कोई बाहर में बैठा हुआ, टिकट भेज देता तो जा सकता है, क्या दिक्कत? तो लेकिन उसको परमिशन लेना पड़ेगा फ्रॉम द एडजुडिकेटिंग अथॉरिटी. The moratorium ceases to effect at the end of the period of 180 days, beginning with the date of admission, unless the order admitting the application is revoked under subsection 2 of section 91. ठीक है. Now 86, very important section, because here in section 85 2b, it says subject to the provisions of section 86. Now, so 86 is very important. So Pradeep ji, 86 पढ़िए जरा क्या है.
Any creditor mentioned in the order of the adjudicating authority under section 84 to whom a qualifying debt is owed may within a period of 10 days from the date of receipt of the order under section 84 object only on the following grounds, namely inclusion of a debt as a qualifying debt or incorrectness of the details of the qualifying debt specified in the order under section 84.
Now here there is a question. Suppose there is a banker. That banker has given a secured loan. So whether that banker can file an objection under section 86? I hope you have understood my question.
But that is not a qualifying debt, I think.
Right. So only those, any creditor to whom a qualifying debt is owed, because excluded debt तो otherwise also is not being discharged, है ना, वो तो as that stands as it is, तो इसीलिए उसको ऑब्जेक्शन करने का कोई पॉइंट नहीं यहाँ पर, है ना.
First of all, it will not be included in the order itself.
नहीं, in the order what will be included? Yes, yes. In the order it says it has been accepted as qualifying debt. Yes. Now नहीं आएगा उसमें. Yes, please.
A creditor may file an objection under subsection 1 by way of an application to the resolution professional.
So this is important, that the filing of objection has to be with the RP. He is not filing the objection with the adjudicating authority. है ना? He simply got a copy of the order, because all the creditors will be given the copy. लिखा ना? Shall be provided to the creditors mentioned in the application. And who will be the creditors mentioned in the application? All creditors. है ना? तो कॉपी तो सबको जाएगा. ठीक है ना? चलिए. So he will make an application to the, may file an objection by way of an application to the RP. Yes, please.
Yeah.
Next
The
point.
application under subsection 2 shall be supported by such information and documents as may be prescribed. The resolution professional shall consider every objection made under this section. The resolution professional shall examine the objections under this subsection 2 and either accept or reject the objections within 10 days of the date of the application.
So here the period is 10 days. Yes.
The resolution professional may examine any matter that appears to him to be relevant to the making of a final list of qualifying debts for the purposes of section 92.
Right. So he might even amend the list. So he will making a final list of the qualifying debts. Yes.
On the basis of the examination under subsection 5 or subsection 6, the resolution professional shall prepare an amended list of qualifying dates for the purpose of the discharge order, make an application to the adjudicating authority for the directions under section 90, or take such steps as he considers necessary in relation to the debtor.
Yes. Now, the creditor made an application to the RP, but the RP rejected the application, or creditor is not satisfied. Then what happens? That is given in section 87. Yes, please.
The debtor or the creditor who is aggrieved by the action taken by the resolution professional under section 86 may, within 10 days of such decision, make an application to the adjudicating authority challenging such action on any of the following grounds, namely that the resolution professional has not given any opportunity to the debtor or the creditor to make a representation, or that the resolution professional colluded with the other party in arriving at the decision, or that the resolution professional has not complied with the requirements of section 86. The adjudicating authority shall decide the application referred to in subsection 1 within 14 days of such application and make an order as it deems fit. Where the application under subsection 1 has been allowed by the adjudicating authority, it shall forward its order to the board, and the board may take such actions as may be required under chapter 6 of the part 4 against the resolution professional.
Yes. Suppose there is an allegation of collusion, etc. So then a copy will be forwarded to the board also. Now section 88. Section 88 talks of the general duties of debtor. ठीक है? जनरल ड्यूटीज ऑफ डेटर क्या है? वही बहु वाली ड्यूटीज है भाई, जो कहा मानो. मेक अवेलेबल टू द आरपी ऑल इंफॉर्मेशन रिलेटेड टू हिज अफेयर्स, अटेंड मीटिंग्स, कंप्लाई विद द रिक्वेस्ट, inform the resolution professional as soon as reasonably any material error or omission in relation to the information or document, any change in financial circumstances. भाई केबीसी में कोई इनाम जीत गया, बताना पड़ेगा. Where such change has an impact on the fresh start process. 89. Replacement. Where the debtor or the creditor is of the opinion that the resolution professional is required to be replaced. अब यहां देखिए कोई कमेटी नहीं है, क्या बोल रहा है? डेटर और क्रेडिटर. तो in that case he may apply to the adjudicating authority for the replacement, or adjudicating authority within 7 days make a reference to the board for replacement. Board within 10 days shall revert.
तो क्रेडिटर का कोई परसेंटेज नहीं लिखा हुआ है कि इतना होना चाहिए, इतना
ना, कुछ नहीं लिखा. ऐसा है ना, अभी तो रूल्स रेगुलेशंस तो आए नहीं है ना इसके. आज की डेट में अगर आप इफ यू वांट टू मेक एन एप्लीकेशन फॉर फ्रेश स्टार्ट यू कैन नॉट मेक.
राइट.
वो भी नहीं है. वो रूल्स में क्लियर करेंगे ना क्या है, रूल्स रेगुलेशंस में आएगा. ठीक है जी, चलिए ये हो गया. 90. डायरेक्शंस फॉर कंप्लायंस ऑफ रिस्ट्रिक्शंस. द रेजोल्यूशन प्रोफेशनल में अप्लाई टू द एडजूड. कोई नहीं मान रहा, जैसे सेक्शन 19 है, सिमिलर दिस सेक्शन 90 इज समथिंग सिमिलर टू सेक्शन 19 है ना, सीआईआरपी में है ना.
Yes.
वैसा ही है ये भाई. कोई कंप्लायंस इन केस ऑफ नॉन कंप्लायंस, कंप्लायंस ऑफ ड्यूटीज ऑफ द डेटर इन केस ऑफ नॉन कंप्लायंस, है ना, फॉर डायरेक्शंस. 91. रिवोकेशन ऑफ ऑर्डर एडमिटिंग एप्लीकेशन. एप्लीकेशन एडमिट हो गई है बट नाउ दे वांट टू रिवोक इट. तो इन दैट केस who will make the application? The resolution professional may submit an application to the adjudicating authority seeking revocation of its order made under section 84. कौन कौन से ग्राउंड्स हैं? There is a change in financial circumstances of the debtor. कोई लॉटरी का इनाम जीत गया ये, है ना, तो debtor is ineligible for a fresh start process, or non-compliance by the debtor of the restrictions imposed on him under subsection 3 of section 85. ठीक है. So subsection 3 of section 85 में कौन कौन सी रिस्ट्रिक्शन है? वही ट्रैवलिंग ओवरसीज, एक्टिंग एज डायरेक्टर, फलाना ढिमकाना. ठीक है. Or if the debtor has acted in a malified manner, has willfully failed to comply with the provisions of this chapter, or adjudicating authority within 14 days shall make an order. They may by order admit or reject such application. और उस पे क्या होगा? ऑन पासिंग ऑफ द ऑर्डर द मोरेटोरियम इन द फ्रेश स्टार्ट प्रोसेस शैल सीज टू हैव इफेक्ट and a copy shall be provided to the board for the purpose of recording and entry in the register. 92 discharge order. The resolution, देखो सारा काम कौन कर रहा है? रेजोल्यूशन पर्सनल, यही लिस्ट बना रहा है, यही क्वालिफाइंग डेट्स की इंफॉर्मेशन दे रहा है, एडजुडिकेटिंग अथॉरिटी उस पर ठप्पा मार रही है सिर्फ। 92 डिस्चार्ज ऑर्डर, द रेजोल्यूशन पर्सनल शैल प्रिपेयर ए फाइनल लिस्ट ऑफ क्वालिफाइंग डेट्स, क्योंकि टोटल पीरियड कितना है इसमें फ्रेश स्टार्ट के लिए? 180, 120, 90, कितना पीरियड है?
180.
180, right. The resolution personnel shall prepare a final list of qualifying debts and submit such list to the adjudicating authority at least 7 days before the moratorium period comes to an end. ठीक है, तो by 173rd day इसको देना है. And the adjudicating authority shall pass a discharge order at the end of the moratorium period for discharge of the debtor from the qualifying debts mentioned in the list. ठीक है, so he will be discharged only from the qualifying debts, not from the excluded debts or secured loans or any debt contracted 3 months before. Without prejudice to the provisions of subsection 2, the adjudicating authority shall discharge the debtor from the following liabilities. ठीक है, अगर कोई पेनल्टी लग गया है in respect of the qualifying debts from the date of application till the date of the discharge order, interest including penal interest in respect of the qualifying debts. ठीक है, any other sums owed under any contract in respect of the qualifying debts from the date of application till the date of the discharge order. ठीक है, the discharge order shall not discharge the debtor from any debt not included in subsection 2. ऑर्डर के अंदर लिख दिया जाएगा कौन कौन से डेट से डिस्चार्ज हो रहा है, and from any liability not included under subsection 3. The discharge order shall be forwarded to the board for making an entry, and a discharge order under subsection 2 shall not discharge any other person from any liability in respect of the qualifying debts. Suppose it's a case of a joint loan. ठीक है, so only the person against whom the discharge order issued, only he will be discharged, not the other person. ठीक है, 93. The resolution personnel shall perform its functions and duties in compliance with the code of conduct provided under section 208. तो ये था हमारा फ्रेश स्टार्ट प्रोसेस।
और कोई फीस वगैरह के ऊपर डिस्कशन नहीं हुआ आरपी का?
वही तो है ना जी, अभी है नहीं ना।
हम्म।
अभी क्या है, अभी रूल्स रेगुलेशन तो है नहीं ना। वो जब रूल रेगुलेशन आएंगे तभी तो आएगी ना फीस वगैरह।
60,000 का लिमिट रखा है तो क्या फीस मिलेगा मुझे समझ
नहीं,
नहीं।
ऐसा भी हो सकता है ना कि एक्चुअली मे बी दे गिव दी गेट इट डन थ्रू जो लीगल सर्विसेज अथॉरिटी वगैरह, उसके थ्रू कर सकते हैं ना ये।
और मे बी क्रेडिटर से कुछ दिलवा दें।
हाँ, क्रेडिट
नहीं,
से क्या दिलवाना है, क्रेडिट को तो वैसे
तो
कुछ नहीं
देना
दिलाएंगे।
है।
उसे छुटकारा पा रहे, राइट?
हाँ, क्रेडिट से तो कुछ नहीं दिलाएंगे, लेकिन ये है कि बोर्ड में वो अपने बोर्ड में बियर दिस फीस, है ना। अब हमने यहाँ क्या किया हुआ है, ये हमने ना इसका पूरा समरी दे दिया पूरे एक्ट का। ये सारा फ्रेश स्टार्ट प्रोसेस सेक्शन 82, 93 सिंगल लाइन समरी है ना। तो दिस यू कैन गो थ्रू। ये इंसॉल्वेंसी का है, ये बैंक्रप्सी का है, और उसके बाद में ये फिर इसकी केस स्टडी भी है। तो केस स्टडी हम अगली बार कर लेंगे, कल कर लेंगे, है ना। तो प्लीज गो थ्रू दिस केस स्टडीज।
कितने मार्क्स का आता है सर?
ये 8 नंबर का आएगा।
इजी है सर।
देखिए ऐसा है, इसमें 3 तरह के हैं, फ्रेश स्टार्ट, इंडिविजुअल इंसॉल्वेंसी, बैंक्रप्सी, किसी में से भी आ सकता है। कई बार फ्रेश स्टार्ट में से आता है, तो 8
टोटल 8
नंबर का
नंबर का
आएगा।
आएगा।
है,
टोटल 8 नंबर का आएगा तीनों में से।
हाँ, तीनों में से 8 नंबर का आएगा। अब किसी में से भी आ सकता है, तो इसलिए हमें तीनों ही तैयार करने पड़ेंगे, है ना। तो मेरे ख्याल 3-4 केस स्टडी दे रखी है, कुछ ना कुछ समझ आ ही जाएगा आपको। तो एक बार देख लेंगे, फिर इसको अगली बार कर लेंगे हम लोग, है ना। कल करते हैं इसको। ओके जी,
सर
एपीपीटी सर शेयर किया हुआ है,
अभी कर देता हूँ ग्रुप में।
ओके सर, ओके।
सर आपने क्लास जब स्टार्ट हो रहा था हम लोग का, तो आपने एक पीडीएफ था आपके पास जिसमें जो नए नए रेगुलेशंस आए थे सीआरपी और लिक्विडेशन, वो रेड मार्क्स थे, रेड हाईलाइटेड थे।
हाँ हाँ हाँ,
वो एक बार प्लीज शेयर कर देंगे क्या ऊपर?
अभी कर देता हूँ, यही चैट बॉक्स में शेयर कर देता हूँ।
यस सर प्लीज।
हाँ हाँ,
ओके सर, थैंक यू।
ये इसमें दो है ना, एक तो ये वाला है, ये जो केस स्टडीज वाला कंपाइलेशन जो मैं दिखा रहा था, है ना। और दूसरा वो जो आप कह रहे हो, वो अपडेटेड कोड वाली, वो एक अपडेटेड कोड ही है वो, उसी में मार्क कर रखा है। अभी दिखाता हूँ। ये जो है ना अपडेटेड कोड, बेयर रेगुलेशंस, मैंने अलग से उस अमेंडेड वाले की भी वो लिस्ट बना रखी है। वो भी मेरा एक एनआईआरसी में लेक्चर था, तो वो भी मैं आपसे शेयर कर दूंगा। उसमें क्या है, वो सिर्फ जो अमेंडमेंट हुई ना जिन रेगुलेशन में, वो भी अलग से लिस्ट बना रखी है।
ओके
इसमें मैंने हाईलाइट कर रखा है, ये मैंने दोनों भेज दी चैट बॉक्स में।
सर, वो भी कर दीजिए तो बेटर है।
और वो भी अभी कर देते हैं।
सर चैटबॉट दिख ही नहीं रहा है।
क्यों नहीं दिख रहा?
सर, नीचे में मिलेगा सर चैट बॉक्स, चैट करके जो मैसेजिंग का एक इंडिकेटर काइंड ऑफ इमेज है।
नहीं, दिख नहीं रहा हो सर, उस पे दिखना चाहिए।
डाउन डाउन सर, नीचे में
हाँ, डाउन में ही नहीं दिख रहा, वही।
पार्टिसिपेंट्स, मेरे तो पार्टिसिपेंट्स के बगल में दिख रहा है।
हाँ, वो हमारे में नहीं दिख, पहले मेरे में भी दिख रहा था, अभी नहीं दिख रहा है, क्यों?
मोर में जाइए सर, मोर में।
वो केवल ओनली वही पार्टिसिपेंट ही दिख रहा है, इसको बंद करते हैं, देखते हैं। नहीं दिख रहा है। हम्म, ये पूरा फुल करने, अभी आ गया सर। ओके।
आ गया जी।
जी सर, थैंक यू।
तो इस बेयर एक्ट कोड पे सारे है ना, ये जितने भी अमेंडमेंट्स, रेट सारे रेट्स में, या कुछ छूटे हुए हैं सर इसमें, अपने को करना पड़ेगा?
ऐसा सारे ज्यादातर हाईलाइट किए हुए हमने।
ओके सर।
हाँ, ये भी डाल दिया मैंने आपको। और वैसे तो अगर आप कोड से पढ़ते हैं तो कोड में नीचे लिखा होता है
हाँ
भाई 2024 2025 जो जो भी अमेंडमेंट हुआ। बट अगर रेड में मार्क होके मिल जाए तो और अच्छा है ना, तो इसीलिए मैं रेड में मार्क करवा देता हूँ। ओके जी, गुड नाइट।
ओके, ओके, गुड नाइट सर।
गुड नाइट सर।
ओके, थैंक यू।